Good afternoon. Welcome to Grace and Gavel, where truth meets compassion. My name is Buffy, and I am an almost 18-year criminal defense attorney. Sorry, I had a little bit of issues speaking here clearly. Sorry, I apologize. We are doing part 2 of the mutual combat, giving you examples. Mutual combat when a fight avoids crime and when it doesn't. Welcome back to Grace and Gavel, the podcast where we break down real crime, real law, and the messy world in between. Today, we're tackling a surprisingly common and surprisingly misunderstood question. Can two people agree to fight and not face criminal charges? The answer varies drastically depending on jurisdiction and the facts on the ground. Let's look at some real cases that show the boundaries of mutual combat. First case example, Brown versus State, Georgia, 1967. In this case, the Georgia Supreme Court confronted a situation where two men mutually agreed to fight and were armed. The court discussed the legal concept of mutual combat and acknowledged that mutual consent to fight does affect how the law treats a resulting death. However, the court ultimately affirmed or held up the guilt of the shooter because the defendant had fired multiple times without evidence of a sudden quarrel or passion that could excuse the killing. Why this matters. Although mutual combat was recognized in theory by the court, when deadly weapons were involved, the slice of law did not prevent a murder conviction here because the facts didn't fit a legally excusable scenario. For instance, if there was something such as like self-defense, or they talked about a sudden quarrel or a passion, which would essentially allow him to have a lesser charge than murder, potentially manslaughter, because it was kind of in the maybe heat of passion, depending on whether or not Georgia would recognize that as such. Case example 2, Hunt versus Tennessee. This was Hunt versus State, which was in Tennessee, 1957. In Tennessee, the Supreme Court confirmed that when two people consensually engage in combat, even with a deadly weapon, any killing arising out of the fight is treated as voluntary manslaughter rather than murder because they both gave their consent, right? It wasn't a situation where one person decided it and then was harmed. The key point: manslaughter is an acquittal. It's a lesser charge, but you still get time for that. Time in prison, likely. It's still criminal, just a lesser charge than murder because the consent and heat of passion lower the culpability or lower essentially the guilt, so to speak. This shows that even when mutual combat is acknowledged, it does not erase criminal liability, but it may modify it. Let's talk about case example number 3, State versus Bryan, which was in Connecticut. In State versus Bryan, a Connecticut court dealt with mutual combat in the context of jury instructions. The state refused to allow a mutual combat instruction because there wasn't enough evidence that both parties truly intended to fight with awareness, including knowing each was armed. The takeaway? The court shows how courts scrutinize the evidence of consent, how important the consent can be. If there's no clear meeting of the minds, which is something that was borrowed from contract law, then clearly they weren't on the same page. And so if they weren't on the same page, they didn't have a quote unquote meeting of the minds, that's a contract theory or contract language, then essentially there was no real agreement to fight. Right? If you think you're using fists and the other person has a gun, like, are you guys on the same page? Absolutely not. Then mutual combat isn't even a viable defense. So case example number 4, State versus Taylor, South Carolina in 2003. In State versus Taylor, a South Carolina court found that instructing the jury on mutual combat prejudiced the defendant's ability to claim self-defense. The appellate court said such instruction shouldn't have been given because the evidence didn't support true combat by agreement. And why this matters. This case highlights how misapplying the mutual combat doctrine can fundamentally shift legal burdens. Because ultimately, when this instruction was given, the defendant likely didn't agree to what occurred. That's what I'm kind of construing from what they're saying. And so he was going to claim self-defense, meaning that the other person was the aggressor and he had to defend himself against the aggressor. But mutual combat meant that they both had a meeting of the minds and they both agreed to fight. And the court said no, that instruction should not have been given. So likely it was then overturned. And it says that why this case matters. This case highlights how misapplying the mutual combat doctrine can fundamentally shift legal burdens, which we said already, erroneously forcing the defendant to prove something that prosecution normally must disprove. So essentially, it shifted the burden to the defendant rather than to the prosecution as it should have been. And in contrast, this is military law. The United UCMJ doesn't recognize mutual combat. Under military law, the Uniform Code of Military Justice, UCMJ, there is no mutual combat defense at all. When two service members agree to fight, both can face assault charges. Consent doesn't make it legal, most likely because they're an institution that is built on brotherhood and things of that nature. And so obviously having two people who are supposed to be on the same team fighting probably is not a good thing. This illustrates that even in a structured legal system like the military, consensual fighting is still punishable. And let's talk about a modern statutory example, Texas mutual combat defense. In Texas, there is an affirmative statutory defense, meaning the defense must raise that as their defense. So they have the burden of proving that. Normally, for instance, if you're in a criminal case, what's going to happen is the prosecution has the burden of proving your guilt. But when you have what is called an affirmative defense, it is the purview of the party wanting to assert that defense who has the burden of proving it. So the burden then shifts to them to see if they can actually prove that affirmative defense. That is often labeled mutual combat is what it's called. If both parties expressly or implicitly consented to the fight and no serious bodily injury or weapons were involved, a defendant can argue that consent negates the criminal assault elements. But here, though, consent must be proven because it's an affirmative defense, meaning the burden goes on the defense. And serious injury or weapons can nullify. Nullify means void. It voids the defense. Meaning assault or aggravated assault charges can still stick if those are present. What these cases really tell us in black letter law terms, consent doesn't universally make a fight legal. Even in jurisdictions that recognize mutual combat, consent alone doesn't automatically erase criminal liability. It may only modify charges like reducing murder to manslaughter, as we saw previously. 2, mutual combat defenses are factual, not automatic. Everything in the legal system, or most everything, turns on the facts. The facts can change something very quickly. Courts will look for evidence of clear agreement, shared intent, knowledge of weapons, and actual mutual participation. If one person has their back turned and the person punches them in the back of the head, is that consent? Absolutely not. Before allowing the doctrine. 3, serious bodily injury or weapons can outweigh mutual combat. Most jurisdictions treat a fight with weapons or severe injury as criminal, regardless of consent. Most likely, maybe the other person didn't know that there were weapons and serious bodily injury was going to occur. 4, even when mutual combat applies, it limits, not eliminates liability. So reducing charges or changing how self-defense applies doesn't mean the conduct is lawful. It merely changes how the law labels it. So, next time someone says they both agreed, how is it a crime? Remember, agreement is just one factor among many. Criminal law isn't a private contract between the fighters. Public order, harm caused, weapons involved, and statutory language all matter. And in most of the US, that means a consensual fight can still lead to serious criminal charges. This has been Grace and Gavel, where truth meets compassion. I hope that you will tune in again soon. I have 2 other episodes getting ready to drop for you all. As you know, I've batched quite a few of episodes here recently, and so I have a few more for you. So thank you for tuning in, and I just want to say thank you to all of you for tuning in. And if you have any story ideas or things that you're interested in, feel free to drop them in the community. You know, I respond and add things to the community from time to time. My newest thing is I have the CANA framework and some other things that go in together, if you're all are interested in that, about kind of regulating the nervous system and decision making when you're kind of in a fight or flight situation. So feel free to check that out if you have an interest in that. And thank you so much. It means a lot to me. Your support means a lot to me, and I want to give you guys as much value as possible. So are there things you're interested in? Feel free to drop them in the comments and suggest a topic. I'd be happy to help you out. Thank you so much, and I hope you have a great rest of your day. Bye-bye.